Good morning. Good morning, everyone. I'm just going to wait for some of you guys to trickle in. I have missed you guys. How's everyone doing? Come on in. Good morning, Facebook. Good morning, Instagram. And good morning, YouTube. Um, Sorry, guys. My voice is groggy today. I have a sore throat. You know, I've been away for the last 3 weeks for summer vacation with my kids. I needed that time to decompress, rest, but I am back like I never left. I'm back to serve you all, answer all the questions you guys have. Someone said take calls. I did take some calls, but like my throat is killing me, so I'm going to go as hard as I can until I can't talk anymore. For those of you tuning in for the first time, my name is Aisha Chidoe. I'm an immigration lawyer here in the United States, and I represent clients all over the U.S. with their immigration matters. To schedule a consultation, you can call 678-325-1037 or 407-995-6567. You can also send a WhatsApp message to 404-333-8751. I see someone who said, every time I try to get a consultation, which I get someone else in your office, I'm frustrated. Why are you frustrated? We have very many capable attorneys here who you can consult with. Sometimes I'm not available. The last 3 weeks I've been out of the country. I was actually in Asia for the last 3 weeks. I'm severely jet lagged right now. Because I got back like 24 hours ago, but we're pushing. So anyone you speak with that's a part of our firm. You're still in good hands. I still oversee every case here. No case is submitted without me going through it and analyzing it. So it really doesn't matter. Even if you don't get me, just trust that you are in good, capable hands. Okay, today I want to talk about conditional green cards and just kind of like some of the trends that we're seeing, because I just want to make sure that I just want to make sure that you guys are aware of this, because I know that there are many people who their conditional green cards are probably about to expire, or they're in the process of trying to renew. So first of all, what is a conditional green card? Let's start with that. A conditional green card is a green card that is given to you for 2 years if at the time they approve your green card, you and your spouse have been married for only 2 years, for under 2 years, or if your step-parent has been married to your biological parent for under 2 years. If you've been married for more than 2 years, you'll get a 10-year permanent residence. Otherwise, it would be a 2-year conditional green card. Now, what does that mean, or what does that mean for you if you have a conditional green card, and what is the process of removing the conditions on your green card? So there are a few ways that you can remove those conditions on your green card. The first and the most common way to remove the conditions of your green card is that 2 years after you've gotten that green card, well, as early as 1 year and 9 months, you can file a joint filing for removal of conditions on the green card. To remove the conditions. A joint filing means that you and your spouse are still in a happy marriage. You have all the evidence of good faith marriage. And if you're scheduled for an interview, both of you have no problem attending the interview and explaining the situation of your marriage and presenting evidence. Then there are 3 other ways in which you can remove the conditions. 4 other ways in which you can remove the conditions on your green card without your spouse. And these are going to be what we call waiver-based removal of conditions. One is going to be if your spouse is deceased and your spouse passed away. You can file for removal of condition as soon as the spouse passes away. So God forbid, but if your spouse passes away, I don't know, like 3 months after you get your green card, you don't have to wait 2 years. You can file as soon as that event occurs. Please understand that outside of just proving that your spouse has passed away, you still have to prove that you had a good faith marriage. The second ground would be based on divorce. If you remove on the basis of divorce, same with death, as soon as the divorce happens, even if it's before the 2 year or the 1 year, 9 month after you've had that 2 year conditional, you can file for removal of condition. But it is important that you have filed for divorce and the divorce has been granted. Sometimes, some clients or some potential clients will come to us and say, I'm in the process of divorce. I want to file this now on the basis of divorce. Can I file it? The answer is really going to depend on what phase you are in your divorce proceedings, and can we ensure that by the time we submit your case, you'll be divorced? Because what typically happens is if you do a removal of condition based on divorce, and by the time the adjudicator, which is the reviewing officer, is reviewing your case, the divorce is not final. They will then usually send you an RFE requesting for the divorce decree. So you want to make sure that if you're going to submit it, you've at least gotten to the stage where, basically you're essentially waiting for the judge to just sign the dotted lines to say, the divorce is happening. That way you can submit it. Then the other two so in that case, in a divorce situation for removal of condition, you want to make sure that not only do you have a valid divorce, you also want to make sure that you have a good faith marriage. Because again, because you're doing a waiver does not take away that requirement. Now I'm going to get into the two most difficult ways to remove the conditions on your green card, because now not only are you going to need to prove that you have a good faith marriage, there are other things that you're going to need to prove. And the other way would be based on extreme cruelty and battery. What is extreme cruelty and battery? It means that your spouse has been extremely cruel to you. So you see the word here as extreme, that basically to an ordinary person, this is not acceptable. Like, it is so bad that every single person that you give the scenario will say, this is really bad, this is extremely cruel, and you can remove your conditions on that basis. Or if it's battery would be physical abuse. Now, understand that in this category, not only do you have to prove that you have a good faith or you had a good faith marriage, you also have to prove the extreme cruelty, which can be sometimes incredibly difficult. Specifically, why I want to focus on this before I get into hardship is that, with abuse, the standards of abuse are much higher right now, especially when it comes to removal of conditions. When you're filing a VAWA application and you don't have a social security number, you don't have a green card, you don't have anything, you can't report to the police, you can't have joint stuff together, they can even look at it and say, okay, we can see how there's some level of control or power dynamics that stops them from having those things. But when you have a situation like extreme cruelty or abuse in a conditional green card situation, the standards are higher. They will not approve you right now without a psychological evaluation. Either a psychological evaluation, and I say that to say, if you are alleging that the abuse that happened to you is not physical, if you are alleging that the abuse that happened to you is physical, they are expecting some sort of documentation of that physical abuse, whether that's pictures, police reports, court filings, potential arrests. If it's psychological, if it's emotional, they're going to want to see something from a therapist. They're going to want to see something from a member of clergy, like marriage counseling, that you guys might have gone to, like your pastor, your imam, your, rabbi, like, whatever religion you are, like they're going to want to see that analysis. So the standards are much, much higher. And the reason why I'm placing emphasis on this is that, as I'm sure you guys know, if you don't know, with this new administration, any kind of case you file right now, if you get denied, you will receive what we call an NTA. An NTA is a notice to appear in front of an immigration judge, a point blank period. Like sometimes people come to me and say, well, I know I'm eligible for vow, or I have a valid case. I found somebody else and I want to get married. Can I go ahead and just cancel that case and marry the other person? It really doesn't matter what you do. The point is, whatever application you're submitting right now, you need to be so airtight, solid in your application process, because the quickness in denials right now, or making a decision to say, you know what, I'm not even going to give you an RFE. An RFE is a request for additional evidence. I'm just going to deny you. And once I deny you, going into deportation, you really, really have to make sure that you know what you're doing, or that you hire counsel that knows what they're doing to submit your application. The final fourth category in which you can remove conditions on your green card would be extreme hardship. You've heard me use the word extreme cruelty and extreme, in this case now, hardship. So you have to show that there is extreme hardship for you if you're deported back to your home country. They're usually looking at those 2 years in which you've had the green card, and how you can show extreme hardship. Extreme hardship is different from hardship. What is regular hardship? Regular hardship would be, something like, if I go back, it's going to be hard for me to find a job, whatnot, so whatever. That's hardship. But that is, to them, is not extreme hardship, because they're like, well, that's going to be everybody else. Like if you move to a new country, it's not easy to find a job. So you have to show at its core what could potentially happen to you, where it's basically essentially life or death, a situation, like the mental situation, psychological situation, like, to be able to overcome the burden of proving extreme hardship. And the reason why I want to focus on this is because a lot of you this year are the batch of applicants who applied for the very first set of the previous administration's interview waivers, meaning a lot of you had interview waivers. Like a lot of you right now that are due for your 2-year conditional removal, a lot of you fell into that category where you had interview waivers 2 years ago, or a year and a half ago, where your interview was waived, your marriage-based interview was waived. So be prepared and understand that you will have an interview, that the scrutiny will be much higher this time because they waived that. And also be prepared and understand that they're not going to want to see any evidence that you submitted in the past. So if you got approved for your green card in 2023, let's just pick a date, like June 2023, for instance, they're not going to want to see evidence from June 2021 or June 2022 or whatever. They're going to want to see evidence from when post submission of your application till the date you applied. So you're going to want to see that, like, let's say you submitted your application in January the year before, something like, I'm just making up random dates, like January of 2022, and let's say you were bypassed in an interview. They're going to want to see evidence from all of 2022, all of 2023, all of 2024, all of 2025, up to when you're applying. So it is really, really important that you are documenting your marriage. Sometimes people are like, well, I didn't document it, or I don't have this. You need to understand that when you are in immigration process, your process is very different from a normal married couple, because essentially, if you're a regular married couple, you're not applying for papers. You just present yourself to the world. You're a regular married couple. It's nobody's business like how you choose to live your lives. But when you are filing for an immigration petition, especially in an administration that is very anti-immigrants, you have to understand that they don't know you. They don't know that your marriage is real or not. So the only way for them to know that your marriage is real is for you to document your process intensely. Guys, I cannot stress that enough. I'm happy to do my next live on what are great documentation suggestions, what are things that you should have, to help show good faith marriage. But hopefully this has provided some, enlightenment to you guys about conditional green cards. Like, I am telling you guys, they are not playing with conditional green card holders. Like, I am telling you guys, like, these RFEs are rough. Like, people coming to us or people that try to dibble dabble, like, do not play around with this or you'll find yourself in deportation. Okay, guys? Okay, I'm going to take some questions. Okay. Judy Sokrim says, Aisha, I really need to talk to you. Please go ahead and schedule a meeting with me. Oyinka says, best attorney ever. Hey, Oyinka, how are you? Emmanuel Florence, good morning. Guys, sorry, I'm so nasally because, as I told you, I have a sore throat. I just have a cold since I got back. Okay, I am Nadiange says, thank you, Attorney Aisha. Your team has been phenomenal. Oh my gosh, thank you so much. I'm so happy to hear that. I got my 10-year green card through marriage in April 2024. I got a speaking ticket in a school zone in April 2025. Can I travel to Nigeria in December without experiencing scrutiny? I can't honestly tell you the answer to that. You can travel to Nigeria. Coming back, you could be asked in secondary review because it depends. There's speeding ticket and then there's speeding ticket. So what are you considered? Like, is it a super speeder? Like, or is it just like a basic speeding ticket? Like, you're 5 miles over the speed limit, 20 miles over the speed limit. Yes, they will allow you back into the country, but you'll most likely probably have to go through secondary inspection depending on what level of speeding. If it's a basic speeding ticket, you should be okay. But anyone right now that has a green card, just understand that you having a green card is not the end all of your process. So you really, really have to be mindful of the law. You really have to be mindful about committing crimes that can still get you deported or get them to take your green card from you. Venice says, can I travel with my conditional green card? As long as you don't have a criminal record or any criminal cases pending, you should be able to travel. Sometimes conditional green card holders will go through secondary inspection, and sometimes a part of secondary inspection also means that they could be going through your devices. So you want to be mindful of all those things and travel accordingly. But yes, that is the whole purpose of a green card, to allow you to come back into the United States freely without any issues. Okay. Okay. Okay, let's see. If my I-485 is approved, do we have to give biometrics again? I already did biometrics after 2 weeks of application, and when will the green card be delivered? Typically, after your green card is approved, then you no longer need biometrics unless you're applying for something else. So if you got a 2-year conditional green card, for instance, and then you're applying again for the 10-year, you'll probably need to do biometrics. But if you're getting a 10-year green card and you got your green card, as of right now, you won't need to do biometrics, but also know that every application that you submit to USCIS, biometrics is involved. So when you are doing your naturalization, which is your application for citizenship, they'll probably also request biometrics. Then sometimes they'll do a bypass, but you'll still have to pay for biometrics. Can you upload additional evidence on the USCIS without an RFE? Absolutely, you can definitely do that. Does USCIS issue notice of intent to deny for valid cases or just RFEs? That is a really good question. USCIS issues both. USCIS would issue a request for additional evidence first, depending on the situation or the case. And then depending on the case, it would be a notice of intent to deny. The difference between an RFE or notice of intent to deny is that with an RFE is essentially saying, we need additional evidence in your file to make a decision. Right. And a notice of intent to deny is saying we have everything we need, and based on everything that we need, we plan to deny you unless you can rebut it with something else. Okay, so but both can happen to the same applicant or one or the other with a VAWA application or any other type of application for that matter. Okay. Okay, Emmanuel says, good morning, attorney. I filed for VAWA in January of 2024. I collected my second prima facie determination. They requested for an RFE since May 2024 on my email, but I didn't receive it on mail requests. I don't. I think you started typing and it cut off. If they requested for an RFE and you have not received it, you should definitely be contacting USCIS. If you have an attorney can reach out through the attorney hotline to request that RFE to be resent because you didn't receive it. You can certainly also try your luck by reaching out to USCIS directly via phone, saying that you didn't receive it. And if you're lucky, maybe they will send that to you as well. Okay. 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 So Shauna says, hello, I did an I-130 interview in May of last year, so 2024, and I got approved. Last week I received a letter with an appointment date for an I-485 interview. Should I be worried? Why would you be worried? You need to do an interview to be approved for your green card. An I-130 is just basically saying that they approve you as a beneficiary to, it's a petition for alien relative, basically saying that they believe that you are whoever. If this is a marriage case, they believe that you are the spouse of the other person. If it's a sibling or parent basis, they believe you're a sibling or a parent. The I-485 is what determines your admissibility into the United States and what makes them determine if or not they should give you a green card. Again, bypasses are not happening again with these types of cases like I-130, 485 cases. So it is part of what you are expected to interview for. You should absolutely not be worried. Just prepare yourself for the interview. And hopefully everything should go well. You can come back and let us know how it goes. Okay. Sean says, is it safe to travel on my combo card? I know people ask me those questions all the time, but it's very, very difficult for me to answer if I don't know your case history. So I can't answer the question for you because I don't know your case history or your case file to be able to tell you if to travel or not. Unfortunately. But, the people who are safe to travel on a normal basis are people who don't have any criminal records, who don't have any removal proceeding, who don't have multiple immigration history cases. This is their one filing. The case is still pending. They've not received an RFE. They've not received an interview notice. They've not received a NOID. Those are the people that typically okay to travel and come back. But without knowing yours personally, it's really hard for me to say. I am so congested. I need to blow my nose, guys. So I'm going to be getting off very soon. Okay, let's see what else. Okay. I have 1 year of tax return. Is that enough with my other evidence, such as renters insurance, life insurance, car insurance? Is that enough for what? I'm not sure what you're applying for, so I can't. Without you telling me what you're applying for, what is this for? Is this what? Are you looking to be a financial affidavit of support sponsor? Are you using this to support good faith marriage in a regular green card application? Is this for conditional removal? I need a little bit more context. I'm on my OPT. It's hard to get a job. Can I get married and get my conditional green card right away? As long as you are marrying genuinely for love, as long as you're not marrying to circumvent the immigration process, and you're marrying because you are marrying for a good faith marriage, then you should have no problem. Janice said, could you advise to travel now on advanced parole? I just answered that question, so you probably heard my answer. Can I use my 10-year green card to travel? Again, 10-year green card holders can travel. You just want to make sure that you don't have any, unclosed or removal cases that are pending. You don't have any cases in removal that are pending. People ask me all the time, how can you have a 10-year green card and have a removal case? The easiest example that I always use is for people who apply for conditional removal. So for instance, if you apply for conditional removal on your 2-year green card and you get denied, and then they send you to removal, and then while you're in removal, you file a new one. USCIS have original jurisdiction, so USCIS can approve you for the 10-year green card, but you still have to go back to court and get that case terminated before you can travel. And also, if you're a 10-year green card holder, you also still have to be mindful that if you have certain crimes that can make you lose your green card status or stop you from getting it, entering into the country, or they will allow you to enter the country and they put you in ICE, detention to, try you or adjudicate your case or situation. So as long as you don't have any of that, you should be fine. Okay. I'm a U.S. citizen filing for my Jamaican spouse. Do I need a USCIS account when I'm filing the I-130? So usually when you apply for I-130, I-485s right now, USCIS usually will give you account access. It's up to you to create your account portal. It doesn't really matter. Like you can choose to create it or not. It doesn't matter. Okay. What's the processing time for VAWA? I applied for VAWA back in June 2022. So you're in the window. You know, VAWA cases can take, anywhere from like 36 months to like 42 months. So like 3 years, 3.5 years is what we're seeing right now. There will always be people that are exceptions, meaning that their cases will get approved slightly earlier, slightly later, depending on any back and forth that has happened in the case. But what I would say is that you're in the window, so any day now, USCIS could be issuing a decision on your case or requesting additional evidence from you. I'm a 10-year green card holder and married to a U.S. citizen, but the relationship isn't working. Can he revoke the green card? No. I filed for VAWA. An RFE was sent but returned by USPS. I've asked for a copy or to be sent back, but they're unable to. What do you mean that you've asked for a copy and they're unable to? Call our office. We should be able to get that for you. You should be able to get the RFE back since there was evidence that they sent it back to USPS. Or USPS returned it back. All right, guys, it was so nice catching up with you guys today. I do have to jump off right now, but I hope you guys have an amazing day. Again, if you want to schedule a consultation to discuss your immigration matter, which really in this day and age, you should be discussing with an attorney, whether it's me or whoever else, call our office. Our numbers are 678-325-1037 or 407-995-6567. You can also send a WhatsApp with your phone number to 404-333-8751, and someone can give you a call back. I hope you guys have an amazing week, and I'll talk to you guys next week. Bye.